Hello, today we will learn about the history of the Indonesian law. Verenigde Oost-Indische Company was founded by the Netherlands merchant in 1602 to have a purpose for avoiding chaotic situation, uncontrolled and unideal situation on the markets of spices. By establishing VOC, the Dutch people is trying to gain the power to control. The power which is gained is used to determine the price of the spices so they can get the benefits and gain more profit if it's sold in the European area. As a merchant company, VOC gets the privilege, special rights such as the right to monopolize trade and shipping, the right to form an army, the right to build a fort, the right to declare war, the right to make peace and agreement, and the right to make money. The Netherlands Indonesia. Under Raffles' control, the prefectures in Java were changed to 19 and regent's power was reduced. In the field of law, the arrangement of the courts is coordinated as the courts in India, that consist of Division Court, District Court, Residence Court, and the Court of Circuit. The Division's Court consists of several native employees, namely the district officer or the village headman and a subordinate employee. They are authorized to try the case of minor and civil offenses with a limit of up to 20 rupiah. The district's court consists of the regent as chairman, chief, prosecutor, and several Bumiputra employees under the leadership of the regent. Its authority is to try civil cases. In making a decision, the regent asks the prosecutor and penghulu for approval. If there is no adjustment of opinion, the case must be submitted to the residence court. And the residence court consists of the residents, regents, prosecutors hoofd, and headmen hoofd. Its authority to try the criminal cases exceeding 50 rupiah with no death sentence, and the Court of Circuit consists of a chairman and one member who served as a circuit court and handled criminal cases with the threat of the death penalty. In this judicial system, adopted a jury consisting of 5 to 9 Bumiputra. The Besluten Regerings era, or the French occupation of 1810 to 1814, resulted in the void of the Dutch state's treasury, filled by implementing agrarian politics in 1826 by the Governor-General Dubas Designes. In agrarian politics, based on Staatsblad 1826 number 6, the convicted Bumiputra with Dwang Sabit or forced labor were divided into two groups. The group sentenced to chain work and was placed in touch plants and will be employed in the open burn worker in Batavia and Surabaya. And the group sentenced forced labor consists of paid and unpaid forced labor. They are placed in work plats and will be employed to lampu establishment established by the government. The Indisch Stadsregeling era. In the provisions of Article 1301 Indisch Stadsregeling, it is stated that there are three groups of inhabitants of the Dutch East Indies, consisting of European, Indonesian, and Eastern foreigners. Residents of the Dutch East Indies who are included in this group are stipulated in the Article 1603 Indisch Stadsregeling. The entire content of the article is quoted from Article 109 Regering Regimen. It consists of 6 paragraphs, which need to be known is the first 4 paragraphs, because the next 2 paragraphs regulate the interest of the population who are still in doubt, which group can ask for the appointment of a judge in that case of 4 paragraphs in Article 1603 Indisch Stadsregeling states. 1. The provisions of the law. 2. Obey to European terms. 3. Obey to the provisions for Indonesians, and 4. Obey to the provisions for foreign Easterners. The Japanese military authority, or the Japanese colonization era, which began ruling Indonesia since they gained power from the Dutch colonial government, who unconditionally surrendered to the March 9, 1942. Abolished the pluralism of judiciary. Ever since, there has been no longer different treatment in administering justice. The Japanese military authority issued law called Osamustirai to carry out their administration. Osamustirai contains general rules in terms of the implementation of military administration in time of need in the state of emergency. Article 3 of the law stated that every government agency and its respective jurisdiction, laws and regulations created by the previous government are declared still in power provided that they are not in contravention with rules created by the military administration. The article obviously served as a transitory provision by which it may prevent the occupied territory as well as the administration for a legal vacuum. Under no circumstances is every government conduct valid without legal basis. The independence of Indonesia. Before the Independence Day of Indonesia, Indonesian Constitution as the Indonesian legal basis was prepared in the periods of Japanese colonization under Dokiritsu Junbi Kosakai. The prototype has been called Jakarta Charter. On its way, this prototype had turned into real form after 17 August 1945, then it called Preambule of 1945 Indonesian Constitution, and its function was to tell about the aim and the purpose of establishment of this country. The periods after the Independence Day is divided into several periods: the Revolution period, the Old Order era, the New Order era, and the Reformation era.